Thank you for joining us today, for making the time. Welcome to our record sealing CLE. It's going to be presented by Joshua Eide. We have great things, great material to cover. Before getting started, I would like to take a minute to acknowledge all of our partners. That is Arkansas Access to Justice, the Friday Firm, Legal Aid of Arkansas, the Center for Arkansas Legal Services, the University of Arkansas School of Law, Southern Bancorp, and Goodwill for making the CLE happen and for helping us with the upcoming Super Saturday clinics. Super Saturday is a series of events that are designed to help low-income Arkansans with tax and legal issues. Later on, Joshua will be touching on some of the details about the Super Saturday program. My name is Ida Chavez de Oseguera. I have the honor to serve as Arkansas Access to Justice new program coordinator. I'll be your moderator today. And just to give you a little more background about who we are, Arkansas Access to Justice is a commission and foundation created by the Supreme Court of the state of Arkansas. And it is basically designed to help, underserved parts of the population. Before getting started with the CLE, I'd like to begin with a few announcements. After this CLE, but before the end of the day, you'll receive an email from me. It will contain a link with a record to the record sealings forms, and also it will have a link to volunteer if you'd like to sign up for the Super Saturday clinics. Just remember, keep in mind that now attorneys can get 1 hour of CLE credit for every 3 pro bono clinics they attend. And so there's no better way to put, what you learned today in practice than by helping out pro bono. Now, in that same email, I'll send a certificate of attendance. Please, I'll be reminding you throughout the CLE to please send that over to me once you receive it. You have 1 week to send it back to me so that you can get credit for attending the CLE. But only those who stay for the entirety of the CLE will be able to get the CLE credit. And if for some reason you get disconnected, we always have some technical issues, just return to the session and shoot me an email and I'll be able to track your time. Now, if anyone wants to refer to this presentation at the end of the day or afterwards, I'll put the video on our YouTube channel. But you cannot receive credit for watching, the video afterwards. We also kindly ask that if you have any questions that are related to the presentation, especially to the topic, you can put them in those in the chat, but if they're not related to the topic, just reserve it for the end. We'll have a 5-minute Q&A session at the end. We would like to get started with 2 poll questions to get to know our audience a little bit better. So if you don't mind, let me have y'all answer these questions. Okay, we'll give y'all 10 seconds to answer these questions. So the first thing is, who are you? We want to know a little bit about your background and then also a little bit about your knowledge. And the second question is, what is your experience with record sealing? So go ahead and answer both now. I see most of you have responded. Okay, we have most participants have answered it. So with that, we'll go ahead and end the poll. We're still missing a couple of people. We're at 89 participation. So I'll give 5 more seconds. Okay, with that, we end the poll. And let's see our results. Joshua, so it seems like we have mostly attorneys in private practice and government attorneys, a few law students, a little bit of core personnel, and I guess some members of the general public. As far as their knowledge, seems like most of our attendees don't have some background knowledge, so it's great to know. That way we know, who our target audience is.
Awesome. Yeah, that's very helpful.
Yeah.
Edith, with that,
Well, I'm sorry.
go ahead.
Sorry, Josh. So I wanted to introduce Joshua Eide. So Josh was super helpful from the very beginning, on board with the project. He has a very extensive knowledge on record sealing. So let me tell you a little bit more about him. He was the supervising attorney. Right now, he's currently the supervising attorney for the Consumer Protection Group for Legal Aid, and he has been in that role since 2021. Prior to joining Legal Aid, he was a deputy public defender at the Washington County Public Defender's Office for 4 years. Joshua's areas of expertise include reentry issues, bankruptcy, debt collections, litigation defense, and vehicle repossession cases. His interest in criminal justice followed him to Legal Aid, where he has helped expand advocacy to other areas addressing incarceration, discharge of cases, and record sealing, just to name a few. Aside from helping folks in his full-time job, he finds time to participate, pro bono in community outreach programs, including speaking in jails and probation or parole offices, community groups, and CLE presentations. So without further ado, let's welcome Joshua Eide.
Hi there. Thank you, Edith. I'm pretty sure all that was true. It sounded a little bit more exciting than I normally am. So yeah, I'm going to go ahead and get started with my presentation. I think that poll was very helpful for me to understand who the audience is and throwing in some tips and tricks as we go along. Is the presentation showing up okay, Edith? Perfect. So
yes, it is.
This presentation is geared towards just CLE. Well, the CLE is geared towards sealing criminal records in Arkansas generally, but specifically also with in mind the Super Saturday event that's coming up. But before I jump into that, most of you probably know who Legal Aid is and who the other nonprofit law firm in Arkansas is, but I want to touch on that really quick. So Legal Aid of Arkansas is one of the two nonprofit or not-for-profit civil law firms in Arkansas. The Center for Arkansas Legal Services is the other law firm. And you can see here on this map, the Center for Arkansas Legal Services covers all the counties shaded green, whereas the Legal Aid of Arkansas covers all the counties shaded in blue. We handle quite a few different areas of law, and we're also very busy. In 2002, we closed a little over 7,200 cases, and a large portion of that was cases involving domestic violence, with just over 2,100. Of those cases, of the full number, 200 or 422 of those were record sealing. So it's definitely a non-insignificant part of what we do here at Legal Aid of Arkansas. A little bit more about us. Again, we are a not-for-profit law firm that helps with civil legal issues. We do have income and other restrictions regarding who we can represent, but we do not charge for our legal services, importantly. We have some strict guidelines on who generally that's at or below the poverty level as promulgated by the federal government. And applying for assistance is pretty easy. So you can definitely direct clients that you're unable to represent to us, to our website, to our helpline number. On the right there, you can see just the breakdowns of the types of cases we handle. We have several substantive work groups, domestic justice being our busiest. We also have a housing work group, consumer work group, of course, the economic justice team. And we have a pretty a good pro bono program. Ashley Norman is our director, and her information is on there. And once or twice, I will pitch you to volunteer your time for more CLE hours to take some cases. It's it's a great opportunity not only to get CLE credit, but also to get good stories, put good bios on your firm's page. So last housekeeping matter is the Super Saturday information. So there's a couple pieces of contact information here on the page, and I think these will be distributed to you, so you don't need to scramble to take a screenshot or anything. But Ivan Martinez is the pro bono coordinator at Center for Arkansas Legal Services, and it's my understanding Ivan will be collecting volunteers for the Super Saturday events. You can sign up to volunteer using that Google Forms link. You can also contact Edith for more information. There will be several different events, and those are throughout February and then in March in several different locations there. You can see all the way from Eudora to Jonesboro. If it's one of your neck of the woods and you're interested in volunteering, we'd love to have you. There's another CLE later today that's presented by Caleb and Jordan from the Friday firm. They will be presenting an estate planning CLE. So these Super Saturday events will have more than just record sealing, more than just taxes. There'll be several different topics that are covered at these events. So skip over the poll since we did that already. To start talking, before I start talking about sealing a criminal record, I think it's really important to understand what a criminal record is. I think it's pretty easy to kind of think of just, oh, your criminal record, but what actually does that mean? How can you explain that to your client, what that is? And I think your client may not realize what all is out there. A criminal record is comprised of the arrest, the charges, the outcome, whether that outcome was probation, what happened when they actually went to court. And as I'll talk about later, that can stop at any point too. And maybe someone was arrested but never convicted. Well, the arrest is still out there even if the conviction isn't, or if there was no conviction. Another important thing to remember is, well, who's got this record? Who keeps all these records? And it's a lot more than you'd think. I know I was certainly surprised. The Arkansas Crime Information Center is the kind of repository in Little Rock, through which all things should flow, but don't always. That's a big portion. The court of record, wherever this case was heard, they have their own case file on that case. The arresting agency has their own internal records. The prosecuting attorney has their own file. And then last, private background check companies are often, scraping the internet for mugshots or scraping public records for criminal cases and compiling their own database. So a criminal record can be comprised of many different things, and handling those is a little tricky sometimes. Along with understanding what a criminal record is, I think it's important to understand, what it isn't. So I think a lot of us and potential clients especially kind of use the term expungement interchangeably with record sealing. And while I think that's probably fine for kind of just general nomenclature purposes, it's not accurate. All right, expungement in other states, and I think implies, just by the nature of the word, that the record is destroyed. It's gone, it's expunged, it's no longer there. But that's not true. We use record sealing. The term expungement isn't found in the statutes we'll be talking about. And it's that process of hiding a criminal record from public view. They can still be seen, and we'll talk about that later too, but in situations you would think, a prosecutor can still see it, law enforcement can still see it, ACIC will still keep the record. It's just stamped, not for public view, sealed. So almost what's the point? When I start explaining that to clients, like, well, if it still exists, what does it matter? And the thing that matters about it is what's actually found in the statute there. And I promise I won't be just reading statutes at you guys, but I think this is an important one. The statute 1690-1417 states, upon the entry of the uniform order, the person's underlying conduct shall be deemed as a matter of law never to have occurred. And the person may state that the underlying conduct did not occur and that a record of the person that was sealed does not exist. So it's kind of powerful language when it comes to being able to hold yourself out or answer questions on applications as not being convicted or not being a felon, not having anything. So it's still worthwhile, even though there are some pros and cons. Again, the benefit of sealing, you can truthfully state the conduct didn't occur. Some employers and housing providers even if they know about it, maybe they do a background check, then you go seal your record, then you come back and apply again, they'll consider it resolved. They may be aware of what record sealing means and what it does. And lastly, I think a lot of clients come to us just seeking closure, trying to make sure they can say their past is behind them. One downside or some cons to sealing a record is that it still may exist with these private background check companies. There's a way to maybe address that, but by and large, the record sealing in Arkansas states that the person who sealed it can do that, can state that it never occurred, but really doesn't have any affirmative effect on telling these background check companies what they have to do with their record. However, with that being said, there still are some rights found under the FCRA that allows individuals to dispute what's been, what's reflected on their background check. So there's always the FCRA to fall back on. And kind of conversely to the point I made earlier, some employers may find out about it even though the client listed, don't have any convictions and say that the person's being untruthful and lying to them. There's important things to remember that record sealing does not do. It does not restore gun rights. It does not remove someone from probation or parole. It does not remove them from the sex offender registry. And it doesn't restore voting rights, but it's important to note that that's actually even easier. A lot of clients come to us wanting to get their voting rights back by sealing their record. And so we do a lot of information kind of dissemination about, you don't need to do this to get your voting rights back. Yes, let's seal your record, but you can vote so long as these other conditions are met.
I think that's a good segue. I'm sorry to interrupt you. I think that's a good segue, Josh, to ask Maria, who had a question. I think you touched on it a little bit, but she asks, does it come up on the background checks once it's sealed?
So yeah, that's a great question. So an ACIC history report, which we'll take a look at later, will still show up. It'll still show that it's been sealed, and ACIC, won't disclose that to anyone, except you, essentially. Private background check companies, again, depends on what information they've gathered independently. But once it's sealed and once you've provided the order sealing to all the relevant entities we've discussed, they will no longer disclose it to anyone that calls up and asks, that submits a background check. So by the way it's supposed to work, no, it should not show up in any background check that is querying one of the state's databases or querying one of the court's files, ideally. Well, but there's some when you're dealing with 6 different entities and their records, sometimes they don't all effectively hide all their stuff correctly, but ideally it's no longer supposed to show up. That's a great question. Were there any others, Edith?
There are others. Johnny asked if there are any limitations to running for political office if the records are sealed. So basically, what's the impact if you seal the record? Can you still run for political office? Yeah,
it's a great question and a little kind of in depth. And I think we can talk a little bit more about this at the end, but generally, yes, if there's a felony, and there's been a few cases, I think this last election cycle where someone's old conviction for like a misdemeanor hot check had popped up. And even though it was a misdemeanor, it involved a crime of either moral turpitude or some other standard such that they were ineligible to run for office. But the short answer is yes. And so it's important to do some research into pulling these separate statutes that relate to running for office and then kind of viewing those in the lens of record sealing. But yes, sealing your record, it can, even if it's sealed, it can still impact your eligibility to run for office.
Yes, and there was another comment on the chat, and it said that it does not in New York if you run for Congress, but we're talking about state specific, correct?
Yeah, definitely. I barely know Arkansas law, so I can't tell you anything about anywhere else. So yeah, this is just applicable to what Arkansas says sealing your records here means.
Thank you.
So I think as I've done tons of record sealing, I've developed kind of what I view as like maybe the best practices or what I think the step-by-step should be as far as sealing your record goes. And if you end up volunteering at any of these events, to obviously not the entire list of things won't happen. We're not going to be having hearings during these volunteer events, but kind of the first part is what we'll focus in on is collecting and reviewing the relevant documents, determining the eligibility of the individual, and then completing and filing the petition and proposed order with the court. Hearing if you end up having one, and then the petition's either granted or denied. It's kind of a good overview of what I view the record sealing process as. So the first step, collecting and reviewing the documents. I think this is pretty essential. Requesting what the state says your client's been convicted of or been arrested for is a great place to start. So the Arkansas Crime Information Center, ACIC, has on their webpage, which I'll show later, a form bank. And on that form bank is a criminal history review request. And so your client will fill that out, notarize it, send it in, and then ACIC will send you a copy of what they show as your client's criminal history. Another important document to gather is the actual charging document. Were they ticketed, in misdemeanor court? Was there a felony information filed showing what they were charged with? And then equally important, if not more so, is the disposition. Was there a sentencing order ultimately entered, either null processing or sentencing your client? And then a satisfaction of judgment is often filed or should be filed. Different counties assign the responsibility for collecting fines to different entities. A lot of the eastern counties and north central that I'm familiar with utilize the sheriff's office. And so the sheriff's office may not be regularly filing satisfactions of judgment. So your client may need to get the receipt from the sheriff showing they're paid in full, and then getting a satisfaction filed by the clerk showing they no longer owe any fines, fees, or costs. So those are the three documents I always like to have in hand before I even begin trying to do anything else. So let's take a look at these in turn. The criminal history form from ACIC. Now this next slide is going to scare everyone. It's not Halloween anymore, but bear with me. This is kind of a screenshot of what an ACIC form kicks back. It almost looks like it should be printed on carbon paper or something. It's got this old type font. It's a little crazy looking. It's definitely not easy to read, but hopefully we'll kind of go through it step by step, and I'll show you what you should be looking for to kind of weed through the morass of the ACIC report. So it's important to note that it's broken down by arrests. So they categorize it by arrest number 1, arrest number 2, and so forth. So here's a smaller snippet, but this is the hardest part. We see here where it's just an arrest. We kind of see these long lines that differentiate between one arrest to another. And so you can sort of sort through the difficult parts or get to the meat of what you always need. Now, the difficult problem with this is, you'd think until you spend a little bit of time dealing with Arkansas politics that the ACIC Little Rock would be 100% accurate. Well, once you start getting into it a little bit more, you note that it's not always accurate. And that's fine. It's just like a puzzle to figure out. The way ACIC works is they rely on entities to report to them what has occurred. So whenever someone's arrested, the police agency sends a report to ACIC. And a lot of that's gotten more automated. So that's not as big of an issue as it used to be. But sometimes the court may not send into ACIC what the disposition of the case was. So in this case here, this little snippet we have is all ACIC shows is an arrest. This person was arrested on 2 counts, and they don't have any more information. So if I come across this, my next step is to look at, okay, this was in Pine Bluff. What jurisdiction court is that? Are these felonies or misdemeanors, or which court was it likely to have gone to? And then contacting those courts to find out, do you have a file? Was this ever filed? Was this charged? What happened? So it's a little bit of hunting down information. And then you can use that information to supplement what you find. So here's a little bit more clear to read ACIC report. That's just an example. It labels kind of what the main information you're looking for is. It lists demographic information first and foremost, your client's name, other demographic information that like a police officer would use: height, weight, date of birth, fingerprints, tattoos, because officers are looking at this as well. When they run someone's background or ACIC, this is what dispatch gets. But important for us are what I have labeled here in the red or the yellow boxes, excuse me. So, from the left-hand side first, the client's name, but then going down, you see the arrest date, the arresting agency. You may use those to go back and find what the court records are. On the right-hand side, we see the top, the SID number. That's an important identifying number that will be used to fill out the petitions. Then going down the right-hand side, there's physical descriptors, but the next important identifying characteristic or number is the arrest tracking number. That is, again, ACIC tracks things by an arrest and associates those things with arrests. So when you send in an order to seal, one of the things they'll be looking for is what arrest to associate that order to seal with. So it's important to find the tracking number for each case you're trying to seal. We see here that the charges at the time of the arrest are listed out and identified by that yellow box. And then we also see an abbreviation for the charge classification level. So here we see this individual, John Razorback, was charged with a misdemeanor, a misdemeanor count of theft of property. And we know that's what it was because in the parenthetical it says MA. So misdemeanor, class A. The second charge says FC. So we know that's a felony with a C level classification. So there's lots of abbreviations that at first are daunting, but as you start working through these more and more often, you'll recognize them kind of off the bat. But this ACIC report suffers from what I identified a minute ago. There's no disposition. It just has an arrest. We don't know what happened. They were arrested on those charged, but as we know, maybe they weren't charged with all of them. The prosecutor reviewed it and dismissed one. Maybe they decided to file none of the above, or maybe it was a conviction. So if we got this back as an ACIC report, we know there's a little bit more digging to do.
We have another good question in the chat.
Absolutely.
Jenna is asking, what do you normally advise clients do in a job application when it asks you, have you ever been arrested or convicted?
Yeah, so if it's been sealed, if it is just a run-of-the-mill background check for private employment, then Arkansas law allows you to state that no, you have not. If it is a application to work at the FBI, I think you need to be a little bit more circumspect and recognize that, as we talk later, there's exceptions for law enforcement purposes and certain types of background checks to where you should probably disclose that. The FBI is going to find out about it anyways. But for just an average background check for employment or for housing, Arkansas law allows you to state affirmatively if you've not been convicted.
And another great question from Erica Miller says, does this apply to people who live in Arkansas and have been convicted in federal law, in federal court under federal law?
Good question. No, this is strictly related to sealing Arkansas state offenses.
Thank you, Josh.
All right. So this next page is a little bit more robust of an ACIC report. Here we've got more than just what this individual was arrested with. So looking at the left-hand side, the top yellow box is the court identifier, and we can see it points to the circuit court that this individual was eventually charged in, the docket number, which will be important to find the documents. And importantly, we see a difference between the filed and the final charge. Anyone who deals with criminal law knows that you're not always convicted of what you're initially charged with. So when you're filling out the petition, and it asks, what were you arrested for? And then ultimately what you were convicted of, those are going to be two different answers. So just be aware of any time you're looking at a filed versus a final charge. Then, of course, it gives information about the disposition, guilty, not guilty, what the sentence was. Of course, one of the dispositions could be a null pros or a dismissal. But the ACIC report isn't, of course, the charging document. Ideally, this is just what the courts reported back to ACIC as to what occurred. So here's another example here that I was just mentioning of the difference between a filed versus the final charge. Here we can see highlighted in the yellow box pointing to the red. Initially, this person was charged with aggravated assault, but ultimately it was a disposition of guilty to a charge of domestic battery in the 3rd degree. So it's important to pay attention to when the filed versus final is different. As I mentioned a minute ago, though, the ACIC is supposed to be just a reflection of what other entities have reported to it. The sentencing order is the controlling document. And I wish I could, have told you here that this is going to be the much easier part to read, but it's not always. Again, don't try to, my eyes aren't very good either. I would try and read all these, but this is an example of why it can be difficult, because this is a sentencing order that may be from years ago. We have a lot of clients who contact us wanting to seal their record from the 90s or from 2000s, some even earlier. So those are difficult to find sometimes. They're definitely not going to be on Court Connect. The entry may be there, but the documents probably aren't uploaded. So it can be another challenge to read the sentencing order, again, which is ultimately controlling. Here's an example of what the sentencing order may look like. Here's another example. Sometimes different jurisdictions, use more fill in the blanks, or they have full typed with no handwriting sentencing orders. But the sentencing order should ideally, be referenced in every petition to seal, because it's going to show what the disposition was. And then here's another example. This one's definitely not pretty to read, but I like to point out with this one, on the right-hand page at the very bottom, you see some additional info that was written in. And what was written in isn't super important, but it just appears to be in this case, and reading it, just keep your eye out for them, because they can be additional sentences or additional requirements to complete the sentence that the judge ordered. And those are just as effective as the little check boxes that the judge has checked in. So if your client was ordered to participate in 20 hours of community service, you need to get documentation from your client showing that that was completed, just in case the court or the prosecutor asks for it. It was ordered, it needs to be completed before you can seal the record. So what information is where? Where can you hunt this down? As I mentioned earlier, ACIC has a form that you can easily print, fill out, send in to ACIC, and get a return of what they have on your client, what they show. And then from there, you can use your client's recollection plus the ACIC report to hunt down any sentencing orders or other information. And then certain types of information that you'll need are located on those documents that you get back. So your ACIC return should show arrest date information about the arrest, identifying numbers such as the arrest tracking numbers. Ideally, it includes the charges and disposition. And then it's provided to you readily, easily. It's you can get it very quickly. The sentencing order has quite a bit of overlap. It should ideally also have all the identifying numbers that you need. The charges and disposition should be on there. The important dates, such as the conviction date, is going to be on there. Sometimes it's on Court Connect. You may find that in certain counties and in certain, however long ago the case was, it may not be on Court Connect. And so there you may need to call the court clerk and request a copy of it either be uploaded or provided to you. But I think it's important to get a copy of both of these in order to do your due diligence before filling out a petition and filing it with the court. So that's all the information you have to gather. So once you gather that and you've read through it and you've assessed it, it's important next to turn to what can you do with it? What's eligible to seal? And there are a few different applicable laws, and the important ones to be aware of is the First Offenders Act, also called Act 346, the Comprehensive Criminal Record Sealing Act of 2013, or CCRSA. The Community Punishment Act is not as important as it used to be, especially prior to 2013, but it still pops up every now and again. And then, of course, specialty courts have their own rules when it comes to sealing records. I find those come up less frequently. I think a lot of the specialty courts, such as drug court or veterans court, are very good at providing services to their clients who graduate. Some of them seal, certainly sealing the offense that the individual is in drug court for, but I don't know that it's unheard of for them to assist sealing other offenses too as part of their reentry process. So I'll talk about these in order, and I do think these are probably in order of importance to know. The First Offenders Act is codified at 1693-303, and this is our most powerful record sealing tool. It has the greatest impact on your client and what their rights are, what rights are restored. To be eligible to use this statute, you must have been sentenced pursuant to this act. You can't just try to use it, even if it is your first offense, after you've been convicted. You have to have been sentenced pursuant to this act, and it must have been indicated on the sentencing order. It's important to note it can only be used once. It can't be used if you go to trial and are found guilty. You must have pled guilty or nolo contendere. Some offenses are not eligible, such as serious violent felonies or felony sex offenses. You must be sentenced to a term of probation, and you must successfully complete that probation. If you are revoked partway through, even if you're sentenced to another term of probation, if there's a finding that you violated, then you can no longer use this Act 346. Sometimes the term is explicitly stated by the sentencing judge, you did not lose your Act 346 status. They're just extending your probation, that's fine. But if there's a finding of revocation by the book, you did not successfully complete your probation. And it's important to note too that there's no waiting period. As soon as you're done with your probation, you're eligible to seal your Act 346 under Act 346. Now, I say this is the most powerful because it's in effect a dismissal. When the judge accepts your guilty plea, they're deferring proceedings in essence. And you'll see on the Act 346 form, it's a dismissal and sealing. So you never finding of guilt. And then in addition, your record sealed on top of that. So it's very powerful. This is the only way to restore your gun rights by record sealing because it's a dismissal. While you're on probation, you're considered a felon, but afterwards, your right to possess firearms is restored. You don't need to go through applying for a pardon.
And Sarah has a very good question in regards to Act 346. She asks, if sentence is under Act 346, is there ever going to be a hearing required, or is it mostly automatic and you can seal it if taken under the 346 Act?
Great question. How good is your relationship with your prosecutor? That's what I found to be the biggest determination of how automatic it is. I think by the book there is, and I'll talk about this a little bit later too, there's no discretion. The judge, it must be sealed. So I almost think it should just be, you can file the motion and the proposed order and the judge should sign off on it, but that's not how it ends up working. The prosecutors, I have found most often won't object, but sometimes it's a struggle to get them to sign off on the orders, which by the statute they don't need to do, but many judges require the prosecutor not to have an objection or to sign off on it. So I wish I had a great answer for your question about how automatic it is. I think it should be very automatic, but in effect it isn't in practice. Some counties and prosecutors are better than others at, recognizing it's a 346, signing it, and going about their day. Good question.
And she has a follow-up. She asks, would local arresting law enforcement block that if they see a client that has another misdemeanor since the Act 346?
I'd like to say no. I don't sometimes know And if there's any prosecutors on here, I'm sorry, but I don't know that the police officers talk to the prosecutors sometimes, so they may not know. In some entities, I know some counties, the DTF has a dedicated prosecutor, so they may have a little bit more of a relationship to inform as to something that may impede the Act 346. But keep in mind too, just being charged with a misdemeanor, if your probation was never revoked, I guess there'd have to be some sort of affirmative. But if your probation's been completed, I think the court loses jurisdiction and couldn't then revoke you when you're off probation. So that's an interesting question. I'm not sure how that would work in practice if you were convicted of a misdemeanor and you're already off probation, but your misdemeanor was convicted during probation, how the prosecutor would know to revoke your probation. I don't know that I've ever seen that come up. I don't know that it would, but I think you can fall back on the fact that probation was never revoked. It was a successful completion of the probation. And therefore, under the statute, you're eligible, your client's eligible to have it sealed and dismissed.
And Alice is asking a great question. We'll go ahead, she posted on the Q&A, but we'll go ahead and answer it. This is related to Act 346. She says, is there a deadline to seal the record when sentenced pursuant to Act 346?
No, not that I'm aware of. I've never encountered that. I've sealed Act 346s, years later. The client thought it happened automatically, which arguably it should. But then they found out when they applied for a job, it's still showing up. So years later, not that there's no deadline that I'm aware of. So the following Act 346 is kind of the next most used or most important record sealing act, and it's called the Comprehensive Record Sealing Act. Someone had an ironic streak when they named it, because I think it's far from comprehensive and there's a lot of moving pieces, and we're going to leave this probably more confused than we started it. So I'm sorry, but I've got my contact information here at the end, and you guys can always contact me if you have questions. But in any case, the CCRSA is found at 1690-1401. It goes through and lists what are eligible offenses, what are ineligible offenses, what the effect of the sealing is, who can it be released to even after it's sealed, the timeliness and process for the prosecutor lodging their objections. It also has a chapter for establishing uniform petitions to seal all these things, because for some reason we can't have one petition that does all of them. We need a separate petition for felonies, misdemeanors, a separate one for controlled substances, which no one ever uses, another one for arrests but not convictions, then another one for dismissals and acquittals. So it's comprehensive, I guess, in the fact that it contemplates a lot of different things, but it also complicates those things. But I'll try to break it down as best I can. I could talk about this for multiple hours, so we're going to fly through some of it. So I apologize, but I am available afterwards, and then in the future, feel free to reach out to me. So misdemeanors, generally they're eligible to be sealed after the sentence is complete. All the terms and conditions of that sentence must be complete. That includes restitution, fines, jail time, reinstating their driver's license. Importantly, there's no limit on the number of misdemeanors that can be sealed under this law. The really only caveat is that there's a waiting period after the completion of the sentence if the conviction was for one of the following, which I like to say they're what you think that they would be: negligent homicide, battery, sexual assault in the fourth degree, both types of battery actually, regular and domestic, indecent exposure, public sexual indecency, driving or boating while intoxicated. Those all have relevant waiting periods, which are found in the statute. Felonies are the comprised of both all 1406, 1407, and 1408. Those go over what felonies are eligible, what felonies are not eligible. But generally speaking, the best way to think about it is felonies you think should be able to be sealed generally are. Felonies that you think maybe probably can, but have a waiting period. So felony classifications that are eligible to be sealed are Class C or D felonies or unclassified felonies. So long as they don't have a a term of imprisonment punished by more than 10 years. Class A or B felonies can be sealed so long as they were drug offenses. not, residential burglary or, any class Ys, but if it's an A or B drug offense, it can be sealed. The language in here is written oddly as to how many you can seal. It states that the petitioner can have no more than one previous felony conviction. It's poorly phrased, but in my experience, it has been interpreted to mean 2 convictions can be sealed as total. I think it could be read in such a way that means if you have 3 convictions, you can't seal anything ever. But in practice, that's not been my experience for how judges or prosecutors even interpret that. So no more than 1 prior felony conviction. So you can seal 1 felony conviction and then this current felony conviction. It's important to note that first offender, if that's not a conviction, remember it was a dismissal. So you can have your First Offenders Act and then seal 2 more felonies after that. The fact that something's been sealed, it still counts as a felony for this purposes. You still, once it's sealed, it doesn't mean you have no convictions. But importantly, the criminal episode rule applies. So if you have, 7 different charges in one case, that's 1 felony for the purposes of record sealing. And I've even had cases where there was 2 separate case numbers, but they were the same charge and committed about a month apart. The court found that that was sufficiently, within 1 criminal episode, it was the same course of conduct, the same exact charge, just 2 separate occasions. I think generally the difference between the charges and the length of time between the 2 will separate the charges for purposes of the criminal episode rule. But if you can slide it all into 1, I would definitely do it. Just like with misdemeanors, you have to have completed all the terms of your sentence, and there's no waiting period for nonviolent offenses, but there's a waiting period of 5 years for violent offenses. And I won't get into this now, or stick around if you want to. The current status of the law is that there's no waiting period for felony DWIs, but there is a waiting period for misdemeanor DWIs. Our legislature made a whoops or just neglected to include some language, but that's the state of the law as it is now. So those are the eligible felonies. Ineligible felonies are found in the same chapter. Kind of, again, just converse of what I mentioned before. Class Y is not eligible. Class A or Bs are not eligible unless they're a drug offense. Felony sex offenses, a felony traffic offense if the felon had a CDL, felonies involving violence. There's a lot of ineligible offenses, and I encourage you to go through the statute and read them. When the criminal record sealing statute refers to violent felonies, it refers to another statute. So you got to hunt down that other statute to see what exactly it means. And so that other statute is 54501. It references other statutes quite a few times, so you'll need to have Westlaw open to poke around. So next is, we went over misdemeanors, went over felonies, both eligible and ineligible. But as we mentioned earlier with what can comprise a criminal record, it could also be things that did not result in a conviction, things such as an arrest, but no charges were ever filed. Going to court, you were charged, but it was null pros or acquitted. Arrests are eligible to be sealed if no charges have been filed after 1 year. Null processes are 1 year after the entry of the order. If it's been dismissed, which there's a subtle but important distinction between those two, which clients find difficult to understand. But if it's been dismissed and the dismissal has been entered, it's eligible right away. Acquittals are eligible so long as the disease, it was not for the reason of mental disease or defect.
Erica had a practice question. She
Okay.
asked, when a minor is charged in a juvenile court and the court orders that the record shall be sealed when the juvenile reaches age of majority, but the person who is supposed to seal the record at the court does not, how do you go about helping these clients?
Yeah, great question. I think I would start with reviewing in this chapter, there's a specific section related to the duties of the clerk when it comes to sealing records. They have to specifically sequester that file, replace the docket sheet with like a blank one, and put it in a different place than their other records. So I would start with just reviewing what the clerk's obligations are under this statute. I'm not familiar with the juvenile code, so there may be some separate area of that code that relates to sealing records. So I can't speak to that. But assuming the order to seal was under this chapter, I would start with the clerk and just make sure you know what the clerk's obligations are. See if you can approach them using, just kind of a congenial relationship and see if they will seal it. If not, then I'm not sure if you need to go to the administrative judge. I think it would just depend, or if you need to go to AOC to kind of raise the issue as to a clerk not following the order of the judge. But this statute does lay out what the duties of the clerk are when it comes to a sealed record. So that's where I would start.
And we have another good question that relates to law students and med students and anybody that is applying for a license before the state. They ask, how do you advise a client that knows that is applying, for one of this medical school or law school, that they're going to ask them about whether they had ever been convicted of a felony? Do you even have them go through the trouble of sealing the record? Would they have to disclose it?
That's a good question. It's a tough one. I start by kind of probing the client a little bit to see if they have heard of other people's experiences. If they have other nursing friends that have gone through this, where they've had a record and answered it. I would just try to see and observe what has happened in that particular area of licensing. We may not be familiar with how certain licensing agencies or professions kind of view these things. They may not care. If it's a weed possession from early 2000s, depending on what the profession is, they may not worry about it. There in the chapter, there's a specific subchapter of the statute that indicates who can still see the conviction that's been sealed. A lot of it is what you would think, prosecutors, police departments, any criminal justice purposes, but there's also one relating to licensure for certain professions. So I would review that to see if whatever the profession is or licensing falls under what you would interpret that category to be. Kind of ironically, depending on how, if I'm applying to sit for the bar, I err on the side of disclose. But I would disclose that it's been sealed. I would state what the offense was, and then the sealed date. I think by the statute, and also just being involved in the court, they're probably going to find it. And so I would err on the side of it being disclosed, but sealed, which defeats the purpose of the record sealing, right? Which is a very frustrating component of this, and one I wish the legislature would address with a little more clarity. So I wish I had a perfect answer for your question, but I would say just, the more kind of dealing with vulnerable populations, the profession is, or the licensure is, such as becoming an attorney, a nurse, a doctor, I would err on the side of disclosure, but stating that it's been sealed per court order. And I think that plus, maybe pointing the individual reviewing the application towards the statute, stating that it's deemed by law never to have occurred. That's some pretty serious language. So I think that may solve the issue. Not a perfect answer, I'm sorry.
And when you seal the record, is it going to be the entire case, or is it just the number of each charge, or how does that work? That's what TK asks.
Sure, that's a great question. What does record sealing look like? So as a practical matter, like let's just think about Court Connect. You can type in someone's case number or search their name. The clerk pulls it all down. When you search that number in the future, it will just say no results. If you search their name, won't return that result. Kind of behind the scenes, it would be very interesting to ultimately have a court clerk come let us know what it looks like. But by the statute, they are supposed to sequester that file, remove it somewhere else where they keep sealed files. So it can't be easily thumbed through and disclosed to someone just calling to ask, hey, what do you have a case for Josh Eide? They will flip through it and they'll just see an empty docket sheet and know that they can't disclose anything, that they have anything about it. So that's kind of practically what it looks like. When checking with ACIC, they will return a sheet that just says, and you can even see it if you request it yourself or for your client rather, stamped on it, it just says this charge has been sealed, an asterisk above and below it. So they know that it should not be disclosed.
And I just wanted to note that Professor Stallings posted the statute for the juvenile record sealing.
Oh, awesome. Perfect. I'll be taking a look at that later because it's definitely an area that I'd like to know more about.
Perfect.
Great. So some important things I think to look for, we've gone over what important documents you should gather, how you read those documents, and then also kind of the statutes that are applicable. Important things I always want to look for. Use Act 346 if at all possible. It's the most powerful tool we're going to have. It's not going to come up very frequently anymore, but old Act 531 cases, which we didn't really go into much detail about because it doesn't pop up much. This is the Community Punishment Act. Certain Y felonies can be sealed on those. And I'm happy to talk about that a little bit more another time, but just for time purposes, it doesn't come up much, but it's still, if you see something on the sentencing order that says Act 531, take a pause, go find that statute, see if it applies somehow. It's important to note that the petition order can be found on the ACIC webpage, all the petitions, all the orders of the various types. If we have time, I'll show you that webpage, but it's very easy to find. Just Google Arkansas Crime Information Center forms, and it's all under the criminal history section. These forms are difficult to use because they're PDFs that you fill in. And so if you type a long sentence, it's just going to shrink the text very, very small. So I found abbreviations used commonly throughout, criminal defense case or criminal cases are easy or helpful. PCS, possession of controlled substance, things like that. It's important to note that case number formatting. ACIC returns don't do a great job of using hyphens or abbreviations for court prefixes, but it's important to know what case numbers look like, where you're needing to file. 47, of course, is the county code. Then it's going to be what, CR stands for criminal. Is this in the Osceola, the Blytheville district? -12, the year 2012, -345. It's just the case number they assigned it. District courts often don't use that format. They just have a CR, then 2020. And these aren't anyone's numbers. I did 1, 2, 3, 4, 5. So hopefully that doesn't relate to anything. But I also think it's important, since you're going to be dealing with a lot of different PDF documents, naming them clearly can help you stay organized because you're going to be submitting a petition and an order. Quickly, I think it's important to touch on what do you tell your clients to do after the criminal record has been sealed. I think it's important to keep the paperwork safe. That signed order from the judge that's been certified from the court, is important. So keep it safe. I also think it's important to update background check companies. Earlier, I talked about how these background check companies have scraped and aggregated their own data, and they refer to their own database. There's a foundation or a nonprofit called the Foundation for Continuing Justice. And what they do is they will take the order that you submit to them and they will send it out to their list of dozens or maybe even it's hundreds now of private background check companies. And these, big commercial companies should be familiar with what Arkansas law states regarding this, and they should update their records appropriately. So I think this is a very important tool that doesn't, it's obviously not discussed in the statute, but updating the background is very important. I think it's important to run the ACIC report again to check for any errors, and remembering the language of the law, deemed by law never to have occurred. Just a couple random tidbits. Again, record sealing doesn't restore firearms rights unless it's Act 346. It doesn't do those other things. The public defender's clients, the Public Defender Commission has an attorney dedicated to sealing records. So if you're unable to take a case or unable to refer them to us, you may refer them to this email address. And ultimately, if your client's not eligible, consider a pardon. I think that's the next step. Sorry to cram all that there at the end, but I will stick around for questions. I know we're just about out of time, but here's some important contact information. Myself and Edith there on the left. Ashley Norman is the pro bono director here at Legal Aid of Arkansas. If you're interested in volunteering for us, please contact her. Yvonne Martinez, of course, is going to be the point person for getting volunteers for the Super Saturday. The contact information is there as well. And so that's all I've got for now. Did I miss anything? I probably did.
I think we have a lot of questions still. Like Josh said, we're going to stay a little bit longer for those who want to, stay in. And if you decide to log out, that won't affect your CLE credits since you have technically completed the hour. But if you want to stick around to hear the answers, you're more than welcome to. Thank you to all of you that attended today's CLE. Thank you for supporting Arkansas Access to Justice, Legal Aid, and Center for Arkansas Legal Services. We definitely need more pro bono attorneys. So please, if you have the opportunity, volunteer for the upcoming Super Saturday event. Like I said, those are free tax and legal clinics to help low-income Arkansans. They're going to be in several areas of the state. They picked the most underserved areas. So I'll send a link with all the information on that email that I will send before the end of the day today. Thank you for joining us.
Thank you, guys.
So as far as the Q&A, we have right now 3 questions posed, but we also have, now we have 5, but we also have one that was not answered on the chat, and that's super quick. They say, can a sealed record be unsealed?
Interesting. I've never heard of, or I don't recognize anything in the statute that relates to it being unsealed. It can definitely be used for a criminal justice purpose. Let's say, there's several offenses in the code, of course, that enhance based on subsequent convictions. So it can still be used to enhance the secondary or subsequent conviction. I think sealed, according to the statute, it can be used probably for impeachment purposes or against you at a sentencing. But I don't know that I know of any mechanism to unseal it. Unfortunately, it doesn't mean it can't be used against you if you have subsequent convictions.
Yeah, and that's a very good segue for the next question. A frequently asked question amongst the immigrant community is, if you're doing or applying for any kind of immigration benefit, will, in this case, USCIS, United States Citizenship and Immigration Services, be able to view that record?
Yeah, unfortunately, USCIS really doesn't care what Arkansas law seems to say about sealing records. And of course, this is sealing it from public view. It's not expunging your conviction, unless, again, it was Act 346. So generally speaking, it's going to be disclosed, but, an immigration attorney can answer more specifically. And of course, the type of conviction is going to play a big role in how it impacts any proceeding in immigration court. If it's a crime involving moral turpitude, maybe it'll matter no matter what. But if it's not a crime involving moral turpitude, then it doesn't matter. So I definitely, any client you run across that has an issue relating to immigration, if that's not your area, I know there's lots of great immigration attorneys that be willing to speak with you about it.
Jenny asks, in the past, there were many groups exempt from sealing rules, from the sealing rules, like the people applying for certain fields. They would still be allowed to see the sealed conviction. Is this correct?
Yeah, that's correct. The statute goes through a list of reasons a sealed record can still be disclosed and who can be disclosed to. So it's important to give that a look and see. It's not an exhaustive list. They're kind of just categories of employers. Again, I tend to fall back on the more the profession or licensure deals with being involved with vulnerable populations, the more likely it is they'll be able to find it. Or if you're working directly with the state employment, they're probably going to be able to find it. But you still may be able to rely on equity. Maybe some of those odd legal arguments you can kind of rely and fall back on the statute language stating it's deemed by law never to have occurred. To non-attorneys and even to attorneys, that's some very powerful language.
And then the next question is, are there any ways to seal an order of protection? Does it matter if the order of protection was granted or denied?
That's a great question. And it's not contemplated by these record sealing statutes. So we've actually had this question come up before. And the short answer is from my research, I couldn't find any statute that specifically addresses this. So I think it would then just fall back on the traditional, the inherent authority of the court to seal its own records, which courts are very likely hesitant to do. We're kind of falling back on the adage of kind of an open and public court. But I can envision certain scenarios, whether, especially if domestic justice is involved or domestic violence is involved, where a court would agree to seal a record of an order of protection. But to my knowledge, this statute obviously does not address it. And to my knowledge, I don't know that there's an explicit statute just dealing with sealing orders of protection.
Curtis has a clarification question. He asks, is the 5-year waiting period under the CCRSA 5 years from the date of conviction or from the date of completion of the sentence?
That's probably my favorite question of the day. And the answer is you refer to the statute, because in one place, for certain types of offenses, it's measured by the completion of the sentence. So that whenever they finish paying off their fines. And then for another category of offenses, the waiting period runs from the date they were sentenced. So it's, I guess they call it comprehensive, but it's not very comprehensive in terms of consistency. So great question. Check the statute, because it's two different answers depending on what you're trying to seal.
Perfect. The next question is, do you need to list all the charges in the petition or just the primary charge?
It's a good question too. So the petition asks, and ironically, again, they ask for different things depending on which petition you're looking at. Generally, they ask for what you were arrested for, which doesn't really make a difference if you're sealing the conviction. But I err on the side of over disclosure. List everything you were arrested for. And then on the lines for what you're convicted of, list everything you were convicted of. You're trying to seal the entire offense. Some courts I don't know if they're making, things can be difficult in certain courts. I'll say it, politely. Some courts require each charge to be on its own petition. So if I have one case number and 5 charges that I'm convicted of, everywhere else except for a handful of courts just state that, okay, yeah, just put the one case number on it and list all your charges. That's how we handle our sentencing orders. Aren't on one sentencing order per charge. But there's a couple courts that require each charge in that case number to have its own petition. So you have 5 petitions with the same case number, just one charge on each. But just list everything. That's a little bit of a tangent, I'm sorry, but list everything.
Another good practical question is, how long does it typically take for an attorney to complete a record sealing from start to finish?
Excellent question. And if this CLE was like 5 hours long, I definitely would have gotten into more of what a typical timeline looks like. The timeline that the statute contemplates is really just the only timeline they talk about is the prosecutor has 30 days to object to a petition that's been filed. A typical timeline can be much shorter or much longer. And I think it depends on your relationship with that court and that prosecutor. There are some instances where I'm able to do an intake with a client, review their documentation, and I know who the prosecutor is. I know what this prosecutor expects, and I can just email the prosecutor with a proposed order that says, hey, got this guy, here's his satisfaction, he's got nothing since this, will you sign off on this order? So then I never even file a petition. We just kind of circumvent that process and submit a proposed order to the judge, and that's perfectly fine. But then there are some areas where you may file the petition, you wait your 30 days, and you haven't heard anything, and the judge hasn't taken an action on it. If you submit the proposed order, they're going to reject it and say, the prosecutor's got to sign off. So then you've got to hunt down the prosecutor and get them to agree. So I like to tell clients it can take anywhere from 30 to 90 days. But that really heavily just depends on your caseload and who you can wrangle at the prosecutor's office in the court.
Thank you for answering that one. And we have a great question in regards to pro bono work. This is an anonymous attendee. They say they have a license to practice and they may want to help. They can probably do it on Saturdays. How often are they required to appear in court if they decide to, for instance, volunteer for a clinic on Super Saturday?
That is a good question. So the answer is you wouldn't. These clinics are organized in such a way to make it as easy as possible for the volunteers. You know, depending on how the clinic is set up, you know, you may just meet one-on-one with the client who's brought in their paperwork. You may review the paperwork and then you just fill out the petitions for them. And then we provide the petitions to them and they go file it on their own. So we are just assisting with these clinics a lot of times, just with the preparation of documents. You're not signing on to represent this person through the hearing, if there is one. It's just assistance with the preparation of documents and kind of reading through and going through all of the, you know, the ACIC report, the sentencing order. And we definitely need volunteers for that. You know, these clinics, you know, it's great to represent individuals kind of the old-fashioned way, you know, one by one. In our office, we do a lot of that. But clinics are a great way to kind of hammer out a bunch of different, bunch of cases. And I'll give a plug to Ashley Norman again, who's the pro bono director at Legal Aid of Arkansas. Recently, she orchestrated a clinic, and this is different than the Super Saturday clinics, but we had prosecutors there and judges there, and this was over in one specific county. So it was a one-stop shop. The client came in with their ACIC, which we had obtained for them ahead of time, their sentencing order. The volunteers worked with them and filled out the petition and the order. They went over to the prosecutor who signed off on it, handed it to the judge signed off on it, and then gave it to a representative from the court clerk who was going to file it on Monday. So not all clinics are like that. The vast majority of them are just assistance with the preparation of documents. So you're under no obligation to continue representation beyond that.
And David Scott is asking, where are these clinics conducted? And we're talking about two different clinics, and I just wanted to make that distinction. Some of the clinics are done by Legal Aid. There's actually several opportunities. There are some that are conducted by Legal Aid. There's some that are conducted by Arkansas Access to Justice that are solely online when you volunteer for the Free Legal Answers website. And then there's others that are for Super Saturday. And those, we have the dates, that those are like an annual series of events that are conducted in sponsorship with the Friday Law Firm, Center for Arkansas Legal Services, Legal Aid, Goodwill, and a couple of other entities. And basically those are going to be on February 4th on Eudora, February 18th on West Helena and in Little Rock, February the 25th on Locksburg, El Dorado, Blytheville, and also for those who are licensed in Missouri and Indianola, Missouri, and then March 25th in Jonesboro. So I'll send a link on that email, the same email where I will email the certificate of attendance, so that in case you want to volunteer and put these skills to practice, that you can go ahead and select the date.
Yeah, so I finally flipped all the way back to my slide that had the dates. Sorry about that. But yeah, so as she said, there are several Super Saturday events coming up. And later today, again, there'll be another great CLE regarding estate planning, which will also be an area of law handled at some of these Super Saturday clinics.
Given that we have taken so much of your time, I think if you have any follow-up questions or questions that were not answered, feel free to email them, shoot them to me, and I will send them to Joshua so that he can answer them, if that's okay with you, Joshua. Absolutely,
and I think I'll make these slides available to you if you want to include these in your email that you send out later today. Then I'll have everyone's contact information inside of it. And you're welcome to reach out to me if you have issues or case questions you've run across.
Thank you so much. And thanks everyone for joining us today. We really appreciate your support. And if you cannot donate your time, please consider donating money to Arkansas Access to Justice, Legal Aid of Arkansas, and the Center for Arkansas Legal Services, the three pro bono organizations that help out low-income Arkansans in the state. Thank you again. Thank you, Joshua.
Thanks, Edith.
Bye-bye. Thank you, Josh, again.